criminal defense attorney Patrick McDonough. Patrick, great to have you here. Thank you for being here.
Thanks for having me.
You're also a former district attorney, so
Right.
I want to ask you to approach this from a prosecutorial standpoint. If you're the prosecutor, where we are in this trial, what would you be doing at this point to really craft your case to make sure the jury has a good understanding of who committed this crime and how it occurred, please?
Well, I think the real failure on both sides, probably more on the defense than the state, is they have not been as clear with the theory of their case.
Yes.
It seems a little bit like the state is kind of throwing it up. Here's all the facts, and maybe at closing, I'll decide to tie this all together. A real effective attorney, whether it's on the prosecution or the defense, they have the theory of their case and they tell their story from the beginning at voir dire all the way through the case. So what's a little confusing from the prosecution and what they should be tying up is that really McNabb is the one who intentionally did this, but on Bell's side, because of the meth use, because of the house, because of abandoning the child, that was negligent and that she was responsible for the second degree. And they don't seem to be clear on that theory. Worse on the defense side. But even the state side, it doesn't seem like they're really throwing an exact story. And the jury wants a story, right? They want to understand it.
Yes. I think just in general, as people, we want to hear stories. We want to know what the real story is. And the jury is looking for the truth. They're looking to find the truth. As you know this, they're fact finders in this matter. And if it's not a clear picture, it's not up for them to guess as to what the truth is. So what I'd like to do, I'd like to play a soundbite for you now, Patrick. Let's take a look at this interview. This is something that Courtney Bell said, and we'll continue discussing, please. Let's look.
So my baby mom was like, go back there and check on bleeding. So I got up, and as soon as I got halfway down the hallway, I seen her in the TV. There wasn't anything. I went on ahead and went in there to make sure. Well, the first thing I noticed was that she wasn't there. So I was like, oh my God, I started freaking out. You know what I mean? I'm thinking that my little girl's gonna pick her up. She got a bad habit of picking her up and trying to carry her around.
All right, I know it can be a little muffled if that was tough for you to hear at home. Christopher McNabb was talking about the potential involvement of his 2-year-old. This is his 2-year-old daughter, Clarissa, possibly picking up a baby, Kalia, saying that the 2-year-old has a habit of picking things up, carrying them around. Maybe she carried the baby. Who knows if this is part of the prosecution's theory, but I want to go back to that with you, please, Patrick, because something that's very important in this case is the burden rests with the prosecution. Defense has no obligation to put on any evidence. You know this very well. And if they aren't being clear as to who did what exactly, the jury could acquit.
Sure, there's no question. And again, it goes back to that story. They need to be very clear that, look, this is what we have, and they need to highlight the problems where he's talking about in past tense that the child, you know, that he loved the child, and he's talking about the meth use and all of that, and they need to make sure they focus on that. But really on the defense side, and I think there was some discussions earlier, like, are they really trying to blame it on the 2-year-old, right?
Right.
The same thing on the defense side, and even more so. I mean, if you are Bell, you've got to be having the theory of your case early on in voir dire.
Yes.
I would be asking questions like, have you ever been a victim of domestic violence? Have you known a family member who's been a victim of domestic violence? Do you know someone who's been a victim of addiction? Here's Bell's key, if she was really trying to win this case.
Please.
Is think about this. We all raise our children. We're all worried about drug abuse and all those types of things.
Sure.
But every person who has a child that ends up with drug abuse, they think it's because they hung around the wrong person. And from early, what Bell's defense team should have been doing is saying, look, I'm the victim. I've been abused. He's the one who led me into this drug life. He's the one who led me here, and separating herself from McNabb.
Right.
And right now, it's just like, oh, maybe they won't prove it beyond a reasonable doubt. Again,
Right.
It goes back to telling the story, and it starts at voir dire, and it goes through every witness.
You are absolutely right. It's their burden. And if it's unclear, then really the defense can go multiple ways with close, multiple ways. And we've seen so much evidence presented today. I know you've been following along closely, and we thank you for that, Patrick. This interrogation video, we see Courtney Bell in there for what seems like days, but not days, but just hours. And this is the day that they found her beautiful daughter dead in the woods close to their mobile home. We're seeing lots of inconsistent statements. But again, that's all, it is what it is. But if the prosecution isn't clear on how this baby died exactly, what was done to that gorgeous baby's head that caused her death, then what are the statements going to matter? Your thoughts, please, from a defense perspective.
Well, that's right. From a defense perspective, that's exactly what you're looking for. But I want to put that in two different buckets. There's the bucket of there's so much reasonable doubt, right? Well, was
Yes.
this consistent, or could it have been the 2-year-old, or where's the murder weapon, or who did that? And that is something certainly the defense wants to focus on. But again, I think the general strategy of, oh, they're not going to prove their case and we just hope they don't prove it beyond a reasonable doubt, I still think that's a mistake. It doesn't matter if you're the prosecution or you're the defense. You need to have your theory of the case and you need to try to prove it. Even though it's on the state to prove beyond a reasonable doubt the case, you from the defense perspective want your story. And if I'm Bell, I'm saying it's McNabb, right?
Sure.
It is not me. I didn't know about it. I was a victim. You want to put yourself over with the child, that you were a victim of this domestic violence. You're the victim of the addiction that he led you to, right? You want to get on that side. You don't want to be on the side with McNabb where, oh, we were doing meth the night before and I don't really know and who knows what happens. You want to make sure you have your own story.
Certainly. No, absolutely right. Although there is no burden on the defense, I totally appreciate what you're saying is you're saying be an advocate.
Absolutely.
If you're the lawyer and you're representing these two, find the avenues that you need to go down and you need to explore them and hit those points home. And if you do need to call a witness in defense in order to better explain your legal theory, that's what you do, just from an advocacy standpoint.
And again, sure, they have the burden of proof and they got to prove it beyond a reasonable doubt. I'm just telling you, from my experience, both on prosecution and defense,
Yes.
that is a losing theory from the defense side. If you're just saying, well, I hope they don't do it, and then you wonder what they do.
Right.
You need to own it, and you need to say, this is what happened, and you need to sell your story. At the end of the day, even if your story isn't, you don't have to win it. You just got to make sure that's a plausible alternative. If it's a plausible alternative, then you've got reasonable doubt.
Right.
But just hoping the state doesn't do their job is a dangerous defense tactic.
I agree. Patrick McDonough, criminal defense attorney. We're going to ask you to stay with us, please. Have to take a short break. The court is in recess, the case of the state of Georgia versus Christopher McNabb and Courtney Bell. As soon as they go back in, we will take you in there live. Right now, we just need to take a quick break. Lots more straight ahead. All right, welcome back to CourtTV Live. Thank you so much for being with us. I'm Julie Grant. Happy to have your company on this Friday afternoon. We're waiting for the jury to get back from a lunch break. The judge dismissed them right around 12 o'clock. He said come back around 1:20. So I want to bring back in our wonderful guest here. We have Patrick McDonough, criminal defense attorney. You've also been a former district attorney. You know how to approach a case from both sides. And before we left off before the break, we were talking about advocacy and what these lawyers need to do on all sides. Even though there's no burden on the defense, defendants are presumed innocent in every criminal case. They don't have to testify, present a shred of evidence. But to have a legal theory just for cross-examination of witnesses in the opening statements, the closing arguments, which we might see on Monday or Tuesday. I want to pick your brain more from a defense perspective, what you think that these two attorneys need to do in their defenses. And again, as you know, two different defense attorneys representing these two. They could have different defenses. We have yet to see what will be put on. But any guesses you have and any thoughts on what they should do, please?
Well, they certainly should have different defenses because Bell's defense should be she's a victim of domestic violence and also is addicted because he led her into addiction. And as I mentioned earlier, that starts with asking questions of voir dire. It goes through into cross-examining. You put your own experts up to explain domestic violence, the battered syndrome. You talk about addiction and how it can affect you and how it can affect your brain. So Bell needs to be, I'm a victim just like the baby was a victim, right? And he's the bad guy. Now, if you're McNabb, that doesn't work, right? I mean, he's got to have a completely different theory. The only theory that I can see that would work here is that kind of classic other dude did it theory. And that is they should have spent massive amounts of time investigating people that are surrounding this trailer park. Are there other people that use methamphetamine that have been there? Are there other people that have prior criminal records? Is there somebody else that had access there? And what you do is, even if you don't have to prove that other person did it, right? But you certainly say, look, we were asleep. Somebody else came in. It doesn't matter if they were mad at McNabb or if they were coming looking for drugs or what. Something happens to the baby. They drop the baby and they go hide the baby. And these people are sleeping through it. So he needs a theory that there is a plausible other person out there that could have done that to raise that reasonable doubt. So two totally separate theories, if I was trying the case.
Sure. And something I want to ask you, with your experience doing criminal defense, so far these two defendants have not implicated one another, nor have they really contradicted each other in statements. So talk to me how stunning that kind of is, going into a trial where you have defendants where nobody's pointed the finger at the other one or said something different. We saw them just a few moments ago in that interrogation video. They're hugging, they're embracing each other. Is that a little bit surprising?
A little bit. I mean, I think McNabb would probably have a hard time putting it on her, right, with all of his actions and what he's done. So again, I think picking on her probably is not the right theory. Again, I would pick somebody else there. From her side, if she really did sleep through this and he did it, she may not have evidence to provide to the state, right? So she might not be able to do that. I think the embrace, if I'm Bell's attorney, I'm owning that, right? He still has control. My baby is missing. My baby is dead. He still got this control over me. And so what you want to do is take what the state's putting up and put it into the theory of your case. There's certain facts that can't change. You got to own those facts and you got to put them into your story. But again, that's why you need a theory from the beginning to the end.
Right. I couldn't agree with you more, Patrick. Something else I want to talk to you about, the drug use. We've heard testimony about drug use by these two defendants, methamphetamine, marijuana. I want to talk about, from an advocacy standpoint, how you deal with this is a bad fact. Like you said, there's some facts that just don't change. You can't change them. There's nothing you can do with that. But is there a responsibility these defense attorneys have to kind of try to explain that? I was talking with my colleague Seema Iyer about perhaps the fact that they should call an expert to explain that this was their normal life, so that those members of the jury who are not drug users and have never used methamphetamine can understand how a parent might behave should their child go missing and the search is still going on.
There's no question. And I've even heard these theories of, oh, the domestic violence can cut both ways or drug use can cut both ways. Look, it's there. You've got to own it, right? So you've got to have both experts work in conjunction. You need the expert to show that she's a battered woman, she wasn't thinking. He's the one that led her to the drug use. And then once he hooked her on the drugs and she's using the drugs, how that clouded her vision. But again, she's got to be the victim, because if she's not the victim, it just goes to the state's case showing that she was negligent, right? Using drugs here, using drugs there. You've got to take each fact. Even the one after the child's missing and she wants to go high. She's got to be so much under control and so much out of her head that you have to have an expert explain how that can happen, because we don't understand that.
Sure.